Hi everyone, I'm Jennifer Armstrong of Jennifer D. Armstrong, LLC, Divorce and Family Law. So one of the questions that I get asked a lot about divorce and family law is how do we come up with a number for alimony? Alimony is an issue that plagues everyone in a divorce, and it's one of the most difficult to also answer. When we're dealing with alimony in a divorce, not only are you concerned with how much alimony needs to be paid, you also have to concern yourself with the length of duration of alimony. How long is the person paying alimony going to have to pay the alimony for? So those are really the two questions you have to answer. You have to answer, number one, if there is alimony, how much is it going to be? And number two, how long is it going to be paid for? So, unlike child support, there is no computerized formula to figure out alimony. Alimony is based on a statute, and that statute has about 14 factors that the court is supposed to take into account when determining the duration and amount of alimony. So the major factors that a court is going to look at is going to be how long were you guys married. So they're going to look at the length of the marriage. They're going to look at the age of the parties, the health of the parties. They're going to look at your incomes. What have you been earning and what is your earning capacity? Is someone underemploying themselves? Is someone purposely unemployed? Are they trying to make their income look lower than it actually should be? They're also going to look at what was your marital standard of living? What types of places did you eat out at? What type of places did you shop at? Were you savers? Were you frugal? Did you not spend a lot of money during your marriage? Or maybe you had a more extravagant or luxurious lifestyle. They're also going to look and see if somebody actually has a need for alimony. They're also going to look to see if the person who is allegedly going to be paying alimony, do they have extra to contribute to the person who has a need for alimony? In more cases than not, the court is being called upon to try to spread the hurt, if you will. At the end of the day, we all know that the incomes that both parties earn probably were needed and necessary to maintain one household. When you're getting divorced, you're splitting that up and you're trying to maintain two households. There clearly is not going to be enough money to go around. So it is unlikely, unless you are high income earners, that there's going to be enough money for both parties to continue to live a lifestyle similar to that which they lived during the marriage, in which case you know that both parties' lifestyles are going to take a hit. And so what the judge has got to do is he or she has got to try to even that out, spread that hurt amongst both parties, given a myriad of factors, most of which are the factors that I just mentioned. Some other factors the court's going to take into account are the children, child care responsibilities, and the courts will also look at the education levels and vocational levels of both parties. Again, this goes back to earning capacity. Should one party be earning more than they actually are making? Are there certain advantages to one spouse having a bigger piece of the pie, so to speak, than the other spouse? These are all things that the court's going to look at. Every judge weighs these factors differently, which is why you could take your set of circumstances to the court, you could take them to 5 different judges, and you could end up getting 5 different answers as to what alimony should be in your case. Every case is unique. Every case is different. You will be hard-pressed to find someone else that has your exact same facts and circumstances and be able to rely on that as a gauge as to what your alimony will be and how long you're going to get alimony for. And that's one of the reasons why it's so difficult to explain to people what alimony should be. So most of the time as attorneys, we have to look at these factors and spend a great deal of time with our clients going over what your budget is, what your lifestyle was during the marriage, what your anticipated expenses after the divorce will be, and we have to take a look at what are the actual resources available. What do the two of you earn? What should you be earning? And those are things that we have to then sit down and take a look at in trying to come up with how much alimony should we be asking for. for, or how much alimony should we be offering? Again, the person paying the alimony is always going to think that they're paying too much. The person receiving alimony is always going to feel like they're not getting enough. It is a misnomer if somebody tries to tell you that there is a computer formula for alimony. That is not true. There is no computer formula for alimony. There are some old rules of thumb that some attorneys and even some judges have used in determining alimony, but again, that's not the law. You can't bank on that. So if you are stuck in your divorce because no one can figure out the alimony, the best thing you could do is speak to an attorney. And again, that's going to be a long, drawn out process where you have to really be realistic about what your lifestyle was, what your expenses are, and what you think you're going to need after divorce. Obviously, you don't want to ask for something that's too little. You don't want to offer too much. But at the same time, it's a balancing act. And that's what makes it so difficult and why most people get hung up on that particular issue. The next thing you need to know about alimony is that if you had settled your divorce back in 2018 or earlier, the alimony used to be deductible to the person paying it. So the person paying the alimony could take a deduction on their federal income tax return of the alimony, and the person receiving the alimony would have to pay taxes on it. That is no longer the case. So alimony is no longer tax deductible or taxable on a federal level to the parties. And as a result of that, some of the alimony numbers have come down. Now that the payers, the people paying the alimony, are not getting a deduction for it, they're not as apt to offer as high an alimony amount as they would have pre-December 31 of 2018. And so, unfortunately, some of the alimony numbers have come down. Again, there are factors each way that have to be weighed. And so the best thing you could do is have a consultation with an attorney so that that attorney can help you determine what a fair alimony award given your special circumstances is. And again, we're dealing with not just the amount of alimony, but also the duration of alimony. If you are married for less than 20 years, it's more likely that you're going to have what's called limited duration alimony, where alimony will be paid to you for a limited duration of time. Of course, there's exceptions to every rule. So if you are married less than 20 years, but there are special circumstances, it is altogether possible that you could make an argument for what used to be dubbed permanent alimony and is now dubbed open durational alimony. Likewise, if you are married for over 20 years, you're going to more likely than not be seeking what is called open durational alimony, which is typically going to be alimony that's going to go typically to the day that the paying spouse retires. Again, this is all fact sensitive. There are exceptions to every rule. Depending upon what occurs at retirement does not mean you automatically stop paying alimony, but alimony will be reviewed at that time. And so again, these are nuances in the law. There is no black and white definitive calculation in determining what alimony is. There is no sliding scale. There is no formula. So you really do need to speak with a professional who can help you on this particular issue. I hope this has been helpful. If you want to schedule a consultation and meet with me or call us up and schedule a telephone consultation regarding this issue, please feel free. Our number is 732-281-6000. Thanks.